Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Aitken Robertson's Legally Speaking YouTube channel, where we dive into important legal topics with professionals who know them best. I'm your host, Melanie van Orde, a licensed paralegal, and today we have a very special guest, Defense Counsel Roshni Gopal, joining us to discuss the crucial subject of sexual assault pretrial applications. Roshni will provide us with some insightful overview of this process and explaining what it entails and its significance in the justice system. So let's get started. Roshni, what types of pretrial applications are typically made in a sexual assault trial?
The most common ones are third-party records, as well as text messages or Instagram messages in the possession of the accused received by the complainant. If the defendant intends to rely on text messages that they've received from the complainant during the course of their trial, the court, as the gatekeeper of evidence, would need to assess whether text messages are records in nature. They take into account whether the complainant would have a reasonable expectation of privacy attached to the messages or the evidence that the defendant intends to rely on. This is both an objective and subjective assessment. The objective assessment is whether the record exposes personal information about one's lifestyle, intimate relations, or political and religious opinions, and whether it extends to the biographical core of personal information which individuals in a free and democratic society would wish to have maintained in confidence and not disseminated to the state or otherwise. The third-party records can include anything from CES records, occurrence reports that the defense would wish to rely on. For these applications, they are typically a two-stage hearing. The application is made. Defense must show that it is likely relevant to an issue at trial or the competence of the witness, and whether the production is necessary in the interest of justice. The complainant is allowed to have counsel present to provide submissions on why the records shouldn't be allowed or be relied on. The judge makes the final call.
Thank you so much, Roshni, for all the information. Thank you to everyone else for joining us today on the Legally Speaking Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defense. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.